Yes, good evening to everybody. Welcome to the today class. And yesterday that I started the economic charts in the part one I completed. In this class, I will try to make it out as far as may possible. Please read the unmute and read what I posted on the screen. Hurry up.
Conspiracy.
What I posted on the screen.
Conspiracy.
Good evening. Namaskar. Conspiracy. That all the things you have to read it. So now you read. Read. Are you hearing me? I said read. Unmute and read. Ravi Kiran. Pallavi. Anyone?
Good evening, Namaskar. Good evening, Namaskar. Section 120A. Ingredients of 120A. There must be two or more persons, must be agreement between themselves. Agreement must be to do or cause to be done. An illegal act, an act not illegal itself by illegal means.
Professor Dr. Mohammed Saheb Hussain. You have to read like a Professor Hussain student, but you did not read. Section 120, capital A. That is the style of reading. So without wasting the time, let me come to my studies. Yes, up to here that yesterday that I dealt the case, because conspiracy, when I say the conspiracy, they do have the common intention, they do take the part in the work, then only we can say the common intention, and it is a conspiracy. Like X and Y, they want to steal something or do something. At that instance, X is guarding at the door, whereas Y proceeds to harm the W, or either beating or any other thing. That means this will be give rise to the thought of conspiracy, because someone is watching either anybody is coming from the outside or not. So he's standing at the door, and the Mr. Y proceeded inside to harm the Mr. W. So they are working for the common intention, for the getting the common cause would be there, and hence it will be set to the conspiracy. The third essential is the presence of some overt act done that cause damage or the harm to the other person. It is an act that done to fulfill the purpose of the conspiracy. The final stage for the completion of the thought of the conspiracy is that some overt act must be done, means physical action should be done. The completion of the conspiracy is not necessarily, even if a certain action is carried out regard the conspiracy, resulting in the damage is sufficient. So now there are something would be there where we can say it's a conspiracy and where we cannot say conspiracy to make a damage to other person also. So that even the exception to the rule is there, and that rule will be clearly mentioned in the Mughal Steamship Company versus McGregor Gowan Company. And this case law we already studied somewhere. Can anyone tell me where we studied this case law? If you know it, you tell me. If you don't know it, just say pass on.
In vicarious liability, sir.
Mughal Steamship Company versus McGregor Gowan Company, we read somewhere. In where we read this case law? Because we already read this case law in some aspect.
Pass on, sir.
See, when I was giving you demnum sine injuria sine demnum, we referred it. There is a substantial damage is caused, but there is no legal injury. Demnum sine injuria, we cited this Mughal Steamship Company versus McGregor Gowan Company. Because in this case law, the defendant were the firm of ship owners who was engaged in the business carrying the free trade between the China and Europe. They are all the ship owners. They came together and offered the reduced freight rate within the intention to monopolize the trade. So they made a lobby and they say, okay, the freight for the kilo or for ton this much, and the resulted, the plaintiff is being driven out of the trade. The plaintiff, the McGregor and company, and Mughal steamship company, they could not bear it, that price. So, result of the plaintiff being the driven out of the trade, who was a rival trader. So, he came out of the trade. The plaintiff brought an action for the conspiracy. But they said it was held that the defendant cannot be held liable as their object was a lawful one, that is to protect and promote their own business interests, and they had used no unlawful means for achieving the same. Even though there is a substantial damage happened to the Mughal ship company, but there is no legal injuries caused. The reason is competition is always allowed in the business. And here also they reduce the rate because they want to increase their business. Yes, if other person wants to be there, okay, he can also do the same business. If not, he can come out of it, but he cannot have a right to file a case against the other person and who made the reduced rate for the freight of supplying the tea from the China to, of course, they said it is engaged for carrying the trade tea between China and Europe. So that is the case law which is there, and this case law will be used in the demnum sine injuria, and the same case law can be used exception to the rule of the conspiracy. Do you think that is a conspiracy? Say yes or no.
No, sir.
There is no conspiracy because in competition it is allowed to reduce the freights.
Business competition is allowed.
Yes. So now let us see the another case law also having the similar nature. Sarel versus Smith case law, and the plaintiff withdrew his order from the R from whom he regularly used to buy his newspaper. So naturally, he used to buy the newspaper from the agent. So he regularly used to buy this newspaper, and he now withdrew from it, taking it from W. So W is another agent is there. He's taking from the W. So defendant were the members of the committee of the circular manager of the London daily papers. Of course, that is a London daily papers. Instead of taking from the W, taking from the R, he's taking from W. So they threatened W. What? Don't sell the newspaper to that fellow. They threatened the W for cutting off his supply of the newspaper if he still continued to supply the newspaper to the plaintiff. The act done by the defendant was done for the promoting their own business interest, and thus they were not held liable because the same newspaper agent of the London daily papers, they want that their sales should be more. Hence, they would like to give the chance to R, where he is taking a lot of number of copies. W is taking very few of copies, and where the plaintiff is purchasing the few from them. So at the time, the competition is allowed over there, and it is not a conspiracy, it is not anything, because agents are the same. The act done by the defendant was done for the promoting their own business interest, thus they were not held liable. In this case, the following 2 points were laid down. When two or more persons intentionally come together with the sole purpose of injuring another person's or trade or business, and their act results in damage in the same, then this act will be actionable if it is an unlawful act. But it is not an unlawful act here, what they did in this Sarel versus Smith. So it is not amount to the conspiracy. Of course, there are many cases are there. Sometimes we can say it is a conspiracy. Sometimes we cannot say conspiracy, depending upon the nature of the things. So you can cite at least 1 or 2 cases, but you cannot say to as many as you read it. So these cases which I have mentioned is, which case law is very easy to remember. Please cite that case law. This is also one of the Docker's case law. So if you feel it, it is a very good, that is the Crofter Handwoven Harris Tweed Company Limited versus VTech. This is one of the case law where we can cite it. And another is case law, so there's Scala Ballroom Wolverhampton Limited versus Redcliffe. This is another case law also there, where which is easy to you to mention, and that case law that you can mention it, because there are many cases are there and giving the same principle, but you cannot cite all of them because of the time factor, because of the marks allotted to it. So now let us see this case law is a very interesting case law. Let us see that. There is a Hunter-Larry versus Thornton case law, and the defendant, who were the secretary and a few members of the union, demanded the expulsion of the plaintiff from the union, as the plaintiff is a member of the union, refused to take part in the union call for a strike. So it's too much. Suppose if he wants to be a union member, only that he will keep it out. No. The defendant were held liable for this act, and this act was done for the furtherance of some interest, but an act actuated with the malice and grudges. So if the act is malice and grudges would be there, then we can say conspiracy. But if the act is for the benefit of the employees, if the trade union did it, it is not amount to the conspiracy. So these are all the cases around about says the same thing. Like the Pepsi Foods Limited case law, Bharat Coca-Cola Holding Private Limited. The plaintiff, however, failed to establish the prima facie case. Yet another attempt was being made to procure the degree of damages for the tort of conspiracy. Because whenever a person wants to say the conspiracy, it is he who has to prove it. Suppose if he doesn't prove it, then it will not come under the conspiracy. So there are many other case laws also there where we can say it is a Indian case law, Lindsay International Private Limited other versus Lakshmi Nivas, Mittal and others. The plaintiff initiated an action alleging inter alia unlawful means of conspiracy. The defendant number one is attempt to resist the action with the filing an application, rejection of the plaint, which was dismissed by the single judge of the High Court of the Calcutta, affirmed by the division bench, and finally the Supreme Court of India, whether the plaintiff will succeed in getting the decree for the damages based the tort of conspiracy yet to be seen. So here, if it is really conspiracy is made, then it can be the damages will be awarded. If not, for the benefit of this company, if he did it, then there is no offense of the conspiracy. The same principle is made in the Kuhn versus Latham also. So you can cite only those cases which could remember well. Otherwise, you need not to refer all the cases which I mentioned over here. Is it? Did you get my idea point?
Yes, sir.
Yes, sir.
So suppose the illegal strike is there, the trade union make it out for the benefit of the staff. I mean their employees. Then it is not amount to conspiracy because they do have every right for the benefit of the things they did it. Who? Trade union. So this is also one of the case law, that is the Rohtak Industry Limited versus Rohtas Industry Staff Union. The workmen of the two industrial establishments went on strike. The strike was illegal according to the Section 23, read with the Section 24 of the Industrial Dispute Act 1947. As a conciliating proceeding were pending, the Supreme Court had to decide whether the union was liable to pay the compensation to the management for the loss incurred by them, even though the strike was illegal. Okay, no doubt. It was held that the union was not liable as their only purpose was to be benefit themselves and not to the cause and injury to the management. Because whatever the trade union doing for
Their own benefit.
benefits for the employees, but not to cause any loss to the management. Hence, there is no criminal conspiracy. Of course, conspiracy under criminal law, Section 120A, capital A, Section 120 capital A and 120 capital B of the IPC 1860 says, it is clearly mentioned if you happen to see it. The difference between the conspiracy as tort and criminal conspiracy. In the criminal conspiracy, public at large would be benefited, large would be suffered, but the individual is suffered over there, then it says either you can civil conspiracy or we can say conspiracy is a tort. So that is the distinction. I made it clear here. You will just read it and it is self-explanatory and you will understand it. But all these things you have to write at the time only when it is given in the long question. When a long question is there, what is the economic tort and decided with some decided cases, each one you have to explain it and only one case law you cite it because there are 5 torts are there. The 5 torts, at least one case law you cite it over there. I am sure that if the 20 marks question or 25 marks question is there, definitely out of 25, he will give 20. If I may be the examiner, and if you cite one relevant case law and explain the offense, I will give out of 25, 22 marks. Sir, why you are not giving 3 marks, sir? No, there will be a lot of lacuna would be there in your answer. Are you following me?
Yes, sir.
Yes. So that is the reason one should have to make it. The reason is, in one of the case law, In one of the English case law, in one of the Andhra Pradesh case law, no. You have to cite the
Name of the case law
name
and
of
year
the
if
case
needed.
law. Even though you don't say the citation, doesn't matter. So again, we'll see the next is a malicious falsehood. This malicious falsehood we have studied in the malicious prosecution. The same thing, a little difference would be there. So malicious falsehood, what is malicious falsehood? Is the act of making malicious statement related to the plaintiff to some third party which adversely affect the pecuniary interest of the plaintiff. See, this malicious falsehood and defamation almost looks alike, but a little difference would be there. In the malicious falsehood also there is a wrong statement is there. In the malicious prosecution also there is a wrong statement would be there. But in the malicious prosecution there should be a prosecution. Again, that will come into the picture, and especially criminal prosecution. But in the malicious falsehood, what you have to say? No. Suppose, I don't know whether you heard or not in these days, or some few days back, ICICI Bank is going to be collapsed. Have you heard?
Not sure, sir. We didn't heard.
Yeah, because it is a rumor came over there, and it is going to be collapsed, and it is taking over by somebody else. So there are many people are there, those who withdraw their account from there. So if you make an allegation on any one of the bank, that bank is going to be become pauper or collapsed or financially it is crippled, then the many people will come and take their FDs and accounts from there, and that fellow will suffer a loss. That is the malicious falsehood. Did you get my point?
Yes, sir.
It is not amount to defamation. No doubt it is a defamation in another way, because that going to be collapsed over there, it is nothing but you made a false statement. And that statement is also is said to be the defamation, but exactly it is not a defamation. It is a rumor, it's made over there. But of course, certain things has happened that the rumor came out. And because of the rumor, many people have went and withdrawn their FDs and accounts from there. So that is a malicious falsehood. So malicious falsehood is more specifically wrong towards a person's business reputation. Here, business reputation is lowered down. Am I right? Because you made an allegation to a bank, and the bank reputation goes away. Are you following me?
Yes, sir.
So now if you go to the SBI bank now, sometimes I get frustrated, and nobody cares to give the reply. I had told him, sir, I would like to see the manager. Then at least they say inquiry. In inquiry, there is no one is there. When I asked him, see, in inquiry, there is no one is there to whom I should have to ask. And we are the senior citizens, and we are troubled a lot. No, sir, I will solve your problem. Please tell me. Then overall the problem is solved over. Because it is a government bank. Did you get my point?
Yes, sir.
So in the other banks, no, the reputation will go away. They will call you, they will say you, they will offer you a drink also to you, a cool drink, and they will say, sir, tell me your problem, that we'll see that we will try to solve your problem. Okay, now let us come to the malicious statement made with the defendant regarding the plaintiff business being closed down. Suppose somebody's business is there. If you say that business is closed down, and it will result in the plaintiff losing the customers, and this will be termed as a pecuniary loss to the plaintiff. This is a malicious falsehood for which the defendant would be held liable. Definitely he would be held liable, because the most of the customers will go away. Suppose if we say that he is out of the business. So it is a little bit of difference between the defamation and the malicious falsehood. I did not find one of the case law, but just you write this example of the banks and a business. That's more than enough. So if the derogatory statement is related to goods are there, suppose if it's goods, and it will be known as a slander of goods. Yes, for example, making some allegation of the goods being defective. Suppose if you say some goods are defective and that are produced by the plaintiff, then nobody will buy that defective goods. Then there would be a loss to the plaintiff who is producing such a goods. So the ultimate effect of such a statement is to depreciate the value of the plaintiff goods. Yes, the people think that the goods are not self-sufficient, not standard goods. The law permits making a statement, however false and malicious. That is, When a trader claims that his goods are much better than those of his rival traders, but when there is a false and malicious depreciation of the quality of the another goods, then an action can be brought. Yes. Suppose the 4G is there. Even the Airtel will also make it, and Vodacom also make it out. Even other brands also could make it out. At that instance, they can make only their comparison, but they should not say that product is less, our product is more. They can say, Voda is 4G and we are the 5G. Suppose the Airtel is 4G and we are trying for the 5G, but our bandwidth is more and their bandwidth is, yes, it is a true fact. But don't, there you can discriminate, we can just compare it, but you are not supposed to say that that is a less depreciable quality of the services they do it, and we do a lot of services we do it. No, you are not supposed to say like that. You can say that your product is the best. Am I right? But you don't have any right
Yes,
to say
sir.
that. You don't have any right to say the product of the so-and-so brand is useless. It is the consumer who will decide it. Are you following me?
Yes, sir.
So
Yes, sir.
malicious falsehood distinguished from defamation. A defamation is a little bit of course that also comes to the person or property, but here malicious falsehood is only for the business, goods, and financial loss. So the wrong of malicious falsehood is somewhat similar to that of the defamation, because both these wrongs, the damage is incurred by the plaintiff, definitely. The reason being the statement made to the third person. However, these two wrongs are different from each other, even if they are having similar properties. They are different to a certain extent. In the case of the malicious falsehood, it is the pecuniary interest of the plaintiff which is affected, especially money loss in the malicious falsehood. In the defamation, the plaintiff interest is affected the reputation. See, even the reputation goes over there means financial loss incurred. Is it or not? But merely the defamation,
Yes.
reputation is lowered down. But in the falsehood, no, is the pecuniary loss is caused over there. The essential ingredient in the wrong of malicious falsehood is the existence of an evil motive. In the malicious falsehood, there is the evil motive is there. And whereas the defamation, malice in the sense of the evil motive is not necessary. Sometimes not necessary. Some people, a woman to another woman say she's a prostitute and she's a so-and-so girl and she's having so-and-so. They will make the many allegations because of the jealousy. Are you following me?
Yes, sir.
So there is a little jealousy would be there, but the evil motive is less. But in the defamation, whether you have the evil motive or not, why did you call a particular woman as a whore? Tell me. Did you see that she is doing such a business? Jealousy. Without any intention, they will make it the allegation. So that is a defamation. So malicious falsehood is a similar property with the wrong of deceit as well, which is in the false statement made by the defendant causes loss to the plaintiff. But the two wrongs can be distinguished on the basis that in deceit, the false statement is made to the plaintiff itself and who suffer and acting upon, whereas in the malicious falsehood, the false statement is made to the third party, resulting in the damage to the plaintiff's pecuniary interest. In the malicious falsehood, no, directly you would not say to the bank. To whom you say? The customers, account holders, third party. Are you getting my point?
Yes, sir.
Yes. So this is the difference between the malicious falsehood. Sir, educated and illiterate. Rendu samaname sir. Oh, let me compare like this. Uneducated and
No, sir.
illiterate. Uneducated and illiterate. Rendu samaname sir.
They're almost same, sir, but
No,
not
sir.
No, there is a
They are
lot
perfectly
of
same.
different.
difference is there. Tell me the difference.
Illiterate is someone who is not read one. Uneducated means he doesn't have a minimum moral sense.
Yes, I do admit it. Yeah, that is a distinction. And I will ask you, put, or let me put it this way. Listen my lecturer and hear my lecture. What is the difference?
Listen is understanding the lecture. Hearing is just hearing it.
more concentration is there and interest
Yes.
is there and a purpose is there in listening, and hearing
Listening.
means casually that you hear the things without keeping your mind and alert. That is the difference that you could find it out there. So now passing off. Passing off is very nice thing, because some people, why do you say so? Johnson and Johnson product, please. Whenever you purchase a Johnson and Johnson product, don't buy outside. Buy only in the medical shop. Are you following me? And
Yes,
especially
sir.
in the
Why, sir?
African continent, it is very more. Johnson and Johnson product, no, they'll sell it a very lesser price. I never purchase Johnson and Johnson product, anything from the outer side. I purchase only from the pharmacist, medical shop. So passing off here, what it say? They make the same brand. Like the example will say, Ellora clocks. Did you hear any time Ellora clocks, watches?
No, sir.
They're very famous, like Ajanta now. So nature of the Tata passing is that in case of Ellora industry versus Banarasi Das, that is the Air India, that is the, All India Reporter 1980 Delhi 254, it says, the object of the Tata passing off is protection of the commercial goodwill. Ellora industry is very famous, especially in the manufacturing the watches. But Banarasi Das also made, they put the name, a little difference they kept it. What is they kept it? I will tell you here. So they changed the little customers and the plaintiff, whether the adapted the, instead of keeping Banarsi Das, brothers having the registered trademark of Ellora were selling the clocks under the trade name since 1955. Who? Banarasi Das and brothers were having the registered trademark Ellora and were selling the clocks under the trade name of this since 1955. The defendant started manufacturing the clocks with the trademark Gargo, that is the trademark Gargo, and printed on the dial of the clocks on the cardboard boxes containing the clocks were printed with Ellora Industries, Gargaon, Punjab. They said Ellora Industry, Gargaon, Punjab. Actually, Gargaon, its N should be there. Is it Gargaon, Goregaon? Okay, and I don't know, Goregaon or Gargaon, doesn't matter. But they on the boxes they printed Ellora Industry, Gargaon, Punjab. They adopted this as their trading style of 1962. The plaintiff requested the injunction in order to restrain them for using the mark Ellora. They are not supposed to use the Ellora Industries, any mark which is similar thereto, because Ellora is famous in the market of 1955. They are manufacturing the watches. And they to preventing them from the letting their goods being represented as the goods of the plaintiff, as it was clear case of the passing off. So the another industry keeping the Gargaon industry, they passing off their goods or selling their goods with the name of Ellora. That is called passing off. Did you get my point?
Yes, sir.
పేరేమో ఒకరిది జాన్సన్ అండ్ జాన్సన్ రాస్తుంటది. Actually, అది not the product. They imitated and they are making and they are passing on as if it is a Johnson and Johnson product in the market. So naturally, there is the economic loss to the Johnson and Johnson company, because when they make it, how much the sale in this week or how much the month, why the sale is going down. So they will go into search in the market. The other product came and the people are using that product, which is less cost to our product. Whether that product is our product, no, only packing they made Johnson and Johnson. It is amount to the deceit. It is amount to the total. You can file a criminal case against them. Are you following me?
Yes, sir.
Yes,
But the
sir.
point, or there will be some collaboration with the Johnson people and the other people are there. That's why the business is going on in that way. Otherwise, it will be closed down. Of course, they will search it, they will find, nobody knows from where they got it. Okay, if they want to put it there in the court and they will find it, they will release them, because they are all the vendors and who are the footpath, they will sell the goods. Are you getting me?
Yes, sir.
No, let us see another whiskey. Scotch Whiskey Association versus Parvara Sudhakar. No, sorry. Parvara Sahakar, AR 1992. It is also passing off. The plaintiff used to various well-known Scottish figure of Scottish soldier. Soldier ఉంటే చూసారండి మీరు దేని మీద స్కాచ్ విస్కీ మీద a Scottish soldier or a Scottish headgears or Scottish emblem is there and marked as a distilled Scotch whiskey all over the world. I don't know whether you have seen such a whiskey or not. There is a emblem is
No,
there for
sir.
Scotch whiskey.
We
The
don't know.
Scotch whiskey, there is the emblem is there. Emblem brand is there. There was Regal. Yeah, Shivaji Regal also. No, what the let's go on. This is a different. This is no Scotch whiskey. This is the different. From Scotland. It is directly from Scotland. There would be a soldier would be there. I don't know why I could not see here. See, this fellow is there now. This is Golden Baron, but they say it's a soldier. But anyway, that what I want to say is there is a logo of the Scotch whiskey is there with the soldier. With a soldier. Scotch whiskey figure, Scottish soldier is there, and the headgear Scotch emblem is there, and they are selling it. But the what the defendants amounted to passing of their whiskey as that of the plaintiff as they were manufactured whiskey in India. And these people are manufacturing the whiskey in India using the similar label. Can a person use the similar label of the Scotch whiskey which is from the Scotland? Answer?
No, sir.
No. They are using
No,
the
sir.
similar label and similar figures, similar cotton, similar devices, suggesting that it's a Scottish origin of the whiskey and use the word Scotch. No, one should not use the word of Scotch. And they use the different, of course, unless it is registered. Along with the description, blended with the Scotch. They made the blended with the Scotch. They added it. Of course, the court held that the defendant were liable. Therefore, the order of temporary injunction was passed. Any
Sir, I got
product-
it, sir.
Yes,
The
please.
image.
Yes.
William Lawson's. You can type William Lawson, sir. It is visible.
Yeah, of course. You can take the license from them and you can manufacture in India. Like Suzuki. Suzuki is manufactured in India with taking the license from them. Are you following me?
Yes, sir.
So you can take the license and you can manufacture over here with the Indian government, because India also getting the good revenue in the automobile, like Volkswagen, BMW, MG, and Ford. These are all the, of course, in the automobile, nobody could beat German. Are you following me?
Yes, sir.
What are the German brands?
BMW,
Yes. Only.
Ford,
No, Ford is from USA.
Lamborghini.
Volkswagen also there, no?
Ah, sir, Volkswagen. Sorry.
Volkswagen also is there. And most of the things, they are very branded in the Germans. And they are good in the even rifles also. Anyway, let us see. Another is very interesting. I don't know whether you have gone to Karol Bagh. సార్ మేము వరంగల్ వదిలిపెట్టిపోలేదు సార్, కరీంనగర్ వదిలిపెట్టలే, ఖమ్మం వదిలిపెట్టిపోలేదు సార్. మీరు కరోల్ బాగా ఎక్కడున్నా మాకేం తెలుసు సార్. Yes, this is another illustrating chart of passing of the Kala-Niketan is a very good famous sari center in the Karol Bagh, New Delhi, plaintiff. And the versus Kala-Niketan G10 basement South Extension Market 1, New Delhi, he named also the Kala-Niketan, they made it. The Kala-Niketan G10 he made it, and it is a Kala-Niketan Karol Bagh it is. So almost all, nobody will see whether the G10 is there or not. They will see only Kala-Niketan. So this case also, the plaintiff was having the business under the name of the Kala-Niketan of selling the saris in Karol Bagh, very famous saris. And the Patel market also there, very cheap, you will get the very warm clothes over there in the Patel market, if you happen to go there. Because everybody will call you there from the rickshaw puller or even a auto driver. Sir, The Padal market, or Karol Bagh, they will say, even the busman also. The New Delhi, for more than 20 years, they are there in the field. They had established a good reputation, name, and goodwill in the market, and were having a turnover of several lakhs in the business because Kalaniket. The plaintiff had spent a huge amount of the advertising and then had reached the position which he was having in the market. Of course, they will advertise also in the same way. Of course, when the advertisement, they will show the amount, and that will be exempted in the income tax also. The defendant started the same trade as well as under the same trade name, Kalaniketan, in the South Extension area. So now the competition come because he's also selling the saris. He's also selling the saris with the Kalaniketan extension G10, and that is the passing off he's made. So the original Kalaniketan filed a case under the passing off. Yes, the injunction order would be held liable. It is held that in this case, the case of the disputed trade name, Kalaniketan, was established and achieved the status of a distinctive name of the plaintiff business because he spent a lot of money and the years to bring the name of Kalaniketan saris. The use of the plaintiff trade name by the defendant was to be deceive and most probably cause the confusion and injure the business reputation of the same, and hence the plaintiff was entitled to the permanent injunction. ఇంకొక లివింగ్ ఎగ్జాంపుల్ చెప్తానండి. బవర్చి. అస్సలు బవర్చి ఎక్కడ ఉన్నదో తెలుసా అండి మీకు?
హైదరాబాద్లో
అస్సలు బవర్చి హోటల్.
నో సార్, తెలియదు.
తెలియకుండా ఇంతసేపు ఏం చేస్తానండి? మరి పాస్ అని చెప్పరాదండి నాకు, నేను చెప్తా కదా నేను.
కాదు సార్, ఇప్పుడు ఎక్కడంటే అక్కడ
సంగం థియేటర్ తెలుసా మీకు? సంగం థియేటర్ అది ఏది మన చిక్కడపల్లి చౌరస్తా, వజీర్ సుల్తాన్కి పోతాం మనం, ఏది విఎస్టీ పోతాం, అక్కడికి వెళ్ళి అటు రైట్ హ్యాండ్ లో ఉన్నది బవర్చి. అక్కడ ఒక థియేటర్ కూడా ఉంది, ఇప్పుడు థియేటర్ మూసేసి ఆపోజిట్. దట్ ఈస్ ద ఓన్లీ వన్ బవర్చి, అండ్ దే రైట్ దేర్. దెర్ ఇస్ నో బ్రాంచెస్ ఆఫ్ అస్ ఎనీవేర్ ఇన్ ద స్టేట్. They will write here later, there is no branch of Bawarchi anywhere in our state. అక్కడ బవర్చి పెట్టాడు. అయితే స్పేస్ తక్కువైందండి. ఆపోజిట్ లో కూడా నో దే ఆర్ స్టార్టింగ్. ఐ థింక్ దే స్టార్టెడ్ ఆల్సో. దట్ ఈస్ ద ఒరిజినల్ బవర్చి. ఇక మీకు తెలంగాణ బవర్చి కనబడుతుంది, గ్రీన్ బవర్చి కనబడుతుంది, కొత్తగూడెం బవర్చి కనబడుతుంది, కరాచీ ఇది కరీంనగర్ బవర్చి కనబడుతుంది, గోల్కొండ బవర్చి కనబడుతుంది,
రాయల్ బవర్చి
కనబడుతుంది, న్యూ బవర్చి కనబడుతుంది. ఇదన్నీ పాసింగ్ ఆఫ్. ఇఫ్ దే వాంట్ హీ కెన్ బ్రింగ్ అన్ యాక్షన్. అయితే వాడు బవర్చి పెట్టాడు, ఏం పెడతాడు? తోక తలిగిస్తాడు. ఎక్కడ? ముందటన్నా వెనకన్నా. Of course, I don't know. I don't think that he's registered it. If he registered it, he can challenge it. But if they say, okay, let them keep it. But these are all not the Bawarchi of the same. So that is a beautiful example for the passing off. If the Bawarchi, original Bawarchi wants, no, he can file a case. But that fellow says, I did not keep the Bawarchi. I kept the Royal Bawarchi. I kept the Telangana Bawarchi. If anybody is there in Khammam, when you are going towards the college, you can say Telangana Bawarchi there, opposite to the second two-town police station. Are you getting me?
Yes, sir.
Okay. So these are all the things. Another case law also there, Mrs. Virendra dresses versus Mrs. Virendra garments. See, only the difference is dresses and garments. But the name is same. Are you getting me?
Yes, sir.
Read.
Yes,
you
sir.
unmute and read.
Mrs. Virendra dresses versus Mrs. Virendra garments.
Varinder.
The plaintiff.
Varinder.
Okay. Varinder garments. The plaintiffs were carrying on the business under the name and style of Virendra dresses of ready-made garments. After 2 years, the defendant started the same business in the same street under the name and style of Varinder garments. The court held that these two trade names were similar, which would create confusion in the minds of people and would mislead. Therefore, the plaintiff was entitled to an interim injunction till the decision of the court was passed.
Yes. That means injunction order is given over there because people did not say Varinder and Virendra. Almost look like alike. Virendra and Varinder. అందుకెందుకండి ఇప్పుడు 3 మామిడికాయల అగ్గిపెట్టె చూసారా అండి మీరు? 3 mangoes అగ్గిపెట్టె.
చూసాం సార్. Yes, sir.
Very famous brand అది. If anybody copies it and get there, he will be passing off. Many people are there. That is famous because Sticks are very good. I don't know now the Tiger brand came and what brand. అప్పుడు ఒక పాటి పులి మార్క్ చుట్టాలని ఉండేది తెలుసా అండి మీకు?
No idea, sir.
Oh, that is very famous. Those who are smoking cigar, చుట్టలు తెలుసు కదా మీకు సిగార్?
Chuttal తెలుసు, sir.
Puli mark చుట్టలు is a very famous. If any other brand come with a puli mark, no, and if you sell it, no, that puli mark will bring an action against the person who is selling with the same name. So there are many cases are there where the passing off can be used over there, because using the name and brand of somebody and selling their products, that is called passing off. Is it clear?
Yes, sir. Clear.
Yes, sir.
You can use the two cases enough for the passing off. Kalani కింద ఒకటి తీసుకొని వీరేంద్ర గార్మెంట్స్ ఒకటి తీసుకొని సరిపోతుంది. It is enough, more than enough. So in conclusion, what I want to say, all these torts have the huge importance in the field of tort law, as these are the wrongs which interfere with the contractual and business relations and consequently injure the pecuniary interest of the person. So if the money loss is there, business in relation to the actual or potential loss of the client, and new business opportunities existing and the new business partners are resulting the huge financial loss. And these wrongs are the tortious as well as the criminal in nature and have the various aspects related to thereof require many reforms of becoming such more ascertainable. So these are the things regarding the today's passing off. Now, what are the total 5 are there offenses? Tell me. We read it.
Yes, sir. I remember only a few, sir.
Inducement for the making the breach of contract,
Malicious falsehood,
malicious falsehood,
passing off,
okay, passing off.
defamation,
No, conspiracy.
conspiracy.
One more. Even though it is not order, doesn't matter. One more. Intimidation. So in sequence, I am giving you inducement for the breach of contract, intimidation, conspiracy, malicious falsehood, and the last one is passing off. సార్ మీకు ఎట్లా గుర్తుకుంటుందండి? గుర్తుకునేది 30 సంవత్సరాల నుంచి చెప్తాను. ఆర్ యూ గెటింగ్ మీ?
అప్పటి వరకు మేము పుట్టలేదు సార్ ఇంకా.
Yeah, now you read this one. Everyone. Read loudly.
Tomorrow, that is Shubhodayam Habari is the pass. I'm sorry. Tomorrow, that is Wednesday, 23rd March 2022, is the last date of my online class, as my Oman Airways flight is on 24th March 2022. So I leave Hanmakonda city at 8 a.m. because my flight scheduled departure is at 3:30 p.m. I am boarding international flight, so the passenger should be 3 hours before report to the counter of Oman Airways. It means I should be present at Rajiv Gandhi International Airport, Oman Airways counter at 12 noon. So my Thursday online class is suspended. I land in Vanza Friday on 25th March 2022 at 11:30 a.m. So I do not know where I am given free accommodation for a breathing period or till I take the rented flat or house. So my online class also suspended on Friday too. I would intimate you whether I could handle online class on the Saturday 26th March 2022 in advance. I intimate you in advance. India is 2.5 hours ahead to the Tanzania timings. Till that time, goodbye, Jai Hind. Professor Dr. Mohammed Saheb Hussain.
India is 2.5 hours ahead. Suppose, say about now in the India 7:30. So in Tanzania, what is the time?
10 o'clock. It's 10 p.m.
5:30.
Now India is the 7:30. Then what is the time of Tanzania? 2.5 hours.
5:30.
We are
5 o'clock.
5
5:30.
o'clock. 5 o'clock. Because 5 to 6, 1 hour, 6 to 7, 2 hour, and over 30 minutes. Means India is 2.5 hour ahead. Like Saudi Arabia, same. Dubai, same. Tanzania, same. Kenya, same. Ethiopia, same. Because our same range. One strata is at one level, it latitude or gratitude, you will say no. So only 2.5 hours difference would be there. So tomorrow is the last class. I would like to say, so please pass on this information to each and everybody, and let us see that how best I can do it. Because I already told you that my passion is teaching, my passion is research. These are the two activities of mine. So with
Sir,
this,
will continue after going there, sir?
this is 1 year contract. So I will there for 1 year.
Okay.
For teaching for the masters, I will teach advanced private international for masters and international human rights law for the masters. But intentionally, I have taken to teach for the law of tort to the UG students in the School of Law, that is the St. Augustine University of Tanzania, Mwanza. So I allow teaching. That's why intentionally, actually, the professor's workload is only 2 subjects, means 2 courses, because we do have the research students are there, LLM students are there, sometimes PhD students are there to guide them. So the workload is not even more for us because we guide even for the researchers also. So, but I voluntarily took it to teach to the UG students. Number 1, law of tort, but some other lecturers are forced me, sir, you are good in also in the private international law. So why don't you teach in the private international law? So let us see that how best I could do it, because I am also equally good in the legal research. Because the research, I like it very much. Research activities, research things, how to write it. So these are the things. Then I said that I will make them help in their courses also. But one course definitely I'm going to teach either the law of tort 2. Now the law of tort 2 I have to teach there, because law of tort 1 is the semester 1 and the another semester is law of tort 2. It's a 2 semester course. But in India, how many semester course it is? Yes?
Only one, sir?
How many
Only
semester
one, sir.
course it is?
1, sir.
Only 1 semester course. But in Tanzania, it is a 2 semester course. Because some courses are 2 semesters. There is very, very few courses are there where we can say 1 semester course. Like law of the child is there. It's a 1 semester course. There is a communication skills for lawyers are there. In some university, it's a 3 semester course. Communication skills for lawyers. But here we don't have such a thing, because we don't know whether we are writing in a present tense or past tense or future tense. I will come yesterday. Can you say so?
No, sir. We should not say.
Why?
Will, it represents future tense,
See,
not past.
now, as for the grammar is concerned, I is the first person, and auxiliary verb will should not come to the first person or second person. It should come only for the second person, I mean third person, not to the first person. But usage beats the grammar. We will say I will, but generally I shall. I shall come tomorrow. But we say that I shall come yesterday. It is not the sense. Are you following me?
Yes, sir.
So sometimes, no, whether you know the grammar or may not know the grammar, but you follow the grammar rules and you will speak, because you are habituated to do like that. But a little difference would be there for making. I have done my work today 3:30. No, you are not supposed to say I have done my work today 3:30. No, because when you specify the time, use simple past. I worked, I completed my work at 3:30 today. I have, don't use the have. Present perfect, don't use it. Use past simple. That is the style of writing. If you say so, అరే వీడు ఎక్కడికి వెళ్ళొచ్చిండ్రా ఎర్రగడ్డ అయితే కాదు కదరా బాబు. So people look at you from the toe to Yeah, it is the Indian tradition that in the beginning or the ending of this any program that we will make the play of the national anthem. Now the national anthem will be.
जनगणमन अधिनायक जय हे भारत सारे जहां से अच्छा हिंदुस्तां हमारा। जय हिंद।
जय हिंद।